Bankruptcy law is federal law, which means that it is binding on states and private entities. When an individual has financial problems regarding a home mortgage, which perhaps has progressed to a scheduled foreclosure sale, Chapter 13 of the Bankruptcy Code allows individuals to stop that foreclosure sale, cure any outstanding arrearage at a 0% interest rate, and maintain ongoing payments through a repayment plan that generally lasts 3 to 5 years. At the end of the Chapter 13 plan, the individual can obtain a court order regarding the status of mortgage payments to help smooth the transition away from bankruptcy court supervision. Thus, Chapter 13 of the Bankruptcy Code allows individuals to save a family home, maintain home equity, and help ensure family safety and long-term security. To have a successful Chapter 13 plan, an individual should hire an attorney. When the bankruptcy clerk's office receives Chapter 13 bankruptcy petitions from individuals who represent themselves, very few, if any, make it past the Chapter 13 plan confirmation stage. Sometimes, with individuals who file bankruptcy without an attorney, we see a bare-bones Chapter 13 petition, usually filed to stop a foreclosure, and then the case is administratively dismissed for failure to file certain documents. Sometimes, this practice is part of a mortgage rescue strategy employed by a private company. This practice is illegal, unethical, and moreover, it deprives the individual of the benefits of Chapter 13 after having officially filed for bankruptcy. We will talk more later about why an attorney in a Chapter 13 case might not cost as much as you think, and the legality of filing a bankruptcy case without the intention of pursuing it. The Bankruptcy Clerk's Office has created this video primarily for parties who wish to represent themselves in Chapter 13 whose primary motive for filing bankruptcy is to save a home from foreclosure, and for new to bankruptcy attorneys to provide a full understanding of how Chapter 13 of the Bankruptcy Code can be used to save a client's home, and concomitantly the client's mental and physical security as well as a more secure financial future. This video is divided into 10 parts. First, we will look at the importance of filing a Chapter 13 petition before the foreclosure sale. Then we will dive into the protective power of the automatic stay. After that, we will walk through the key considerations when forming a Chapter 13 plan. Then we will examine the proof of claim. Afterwards, we will do an overview of the confirmation process of the Chapter 13 plan. Following that, we will look at how changes in the fees charged occur and the protections that debtors have against unjust fee changes. With that explained, we will examine the final cure. Afterwards, we will weigh the viability of achieving a similar result through Chapter 7 bankruptcy. Then we'll hear attorney perspectives on non-bankruptcy home rescue solutions and finish by looking at the cost of hiring a Chapter 13 attorney and the value added by doing so. There are several steps to proceeding to a foreclosure sale under state law. At any one of these steps, an individual who desires to keep his or her home, but who does not have the present ability to cure the arrearage or to pay the associated fees, may seek legal counsel. The sooner an individual seeks legal counsel, the better. In West Virginia, however, the notice of the foreclosure sale is the most important document regarding the timing of the filing of the bankruptcy petition. At the time of the creation of this video, there is no provision in West Virginia state law that allows a homeowner a period of time following a foreclosure sale to redeem the property. In the case of In re Bardell, the bankruptcy court held that as soon as the hammer falls at the foreclosure sale, the individual's right to save the home in Chapter 13 bankruptcy filing terminates. Thus, the timing of the bankruptcy petition is of primary importance. It must be filed before the foreclosure sale hammer falls. To avoid evidentiary issue regarding which came first, the filing of the bankruptcy petition or the sale of the property, the bankruptcy petition should always be filed at least one day before the scheduled foreclosure sale. Let's ask Michael Proctor, an attorney in Canonsburg, Pennsylvania, to explain how a foreclosure sale of a person's home in West Virginia generally proceeds and what happens when a bankruptcy case is filed before the foreclosure sale occurs.
So West Virginia is a non-judicial foreclosure state, meaning that the notice process is essentially that the homeowner obligor on the loan documents will get communications in the mail from the lender and or the lender's counsel, and then once the any cure periods that are provided in the loan documents or under state law are satisfied, then the the lender's counsel will send notice of the foreclosure date and time to be held at the county courthouse. So it's a pretty quick process. Usually the lender, once the actual foreclosure notices go out, it usually happens within a month or so.
When you receive a notice that a homeowner has filed bankruptcy, what do you tell your mortgage lender clients?
It depends. Every situation's different. It depends on how far behind the loan is. A lot of times Chapter 13 is a good alternative even for lenders because if a loan's so far behind, it's almost impossible sometimes for people to catch up. So Chapter 13 does provide a structured process whereby the creditors and the borrowers know what to expect and get them back on track.
If the homeowner filed a Chapter 13 case, under what circumstances would you advise the mortgage lender to file a motion for relief from the automatic stay?
Again, every case is different. It depends on the value of the collateral for the loan, how far behind the account is, what else is going on in the Chapter 13 case. If the borrower seems like they're going to be able to catch it up, sometimes that can be worked out rather than the lender taking the collateral back.
In a Chapter 13 case, who generally prepares the proof of claim, and what is counsel's role, if any, in reviewing the proof of claim?
It varies. Some creditors do that entirely in-house, and it can sometimes come to counsel after the claim's even been filed. Other creditors will involve us in that process, and it just kind of dependent on the client on how involved they want us to be.
And what is your experience with a Chapter 13 debtor that seeks to modify the terms of a loan through the Chapter 13 process?
Through the Chapter 13 process, it's as long as they put forth a plan that doesn't put them further in the hole. If it's something that they can realistically accomplish, then Chapter 13 is often pretty successful. Chapter 13, can be beneficial for all the parties involved. Sometimes, from a creditor perspective, sometimes they think, oh, a bankruptcy, that's bad news, but a lot of times it's not. It can even be good news for a creditor in certain circumstances.
The automatic stay is created by federal law and is just that, automatic. It serves an injunction or a prohibition on many different types of collection activities, including the completion of a foreclosure sale. Special rules apply regarding individuals who have filed one or more bankruptcy cases in the past year, and if that is the case, close attention must be paid to the language and rules set forth in U.S. Code Title 11, Section 362C 3 through 4. Once the bankruptcy case is filed and the automatic stay is in place, even if notice is not able to reach the trustee conducting the foreclosure sale in time, the sale is void. Let's ask Ryan Johnson, clerk of the bankruptcy court, how the court sends notice to the creditor foreclosing on the home.
When a bankruptcy case is filed, the individual provides to the bankruptcy clerk's office a mailing list of all the individual's creditors. So it's important to run a credit report before filing to make sure that all creditor addresses and names are on this mailing list, including the creditor and the trustee conducting the foreclosure sale. Now, when the case is filed, we take this information and we issue a notice of case filing, and that notice contains a case number, the individual's name, and a bunch of important dates and deadlines in the bankruptcy case. And we issue that notice to every creditor on the mailing list. Now, some creditors receive the notice electronically, which means they will receive it the same day as the bankruptcy case is filed, or that same evening. And those who have not signed up for electronic notice, those that aren't national creditors for the most part, receive the notice by mail. And so it can take 5 to 7 days for the notice of case filing to be delivered to a creditor who has not signed up for electronic notice. Therefore, when a foreclosure sale is scheduled within a week or so before the bankruptcy petition, it's important that the individual obtain their case number and send that case number directly to the entity, the trustee, or the creditor that's conducting the foreclosure sale. And so they have notice of the bankruptcy filing and notice that the sale will be stayed by virtue of the Bankruptcy Code's automatic stay.
The important thing to remember about a Chapter 13 plan is that it must be supported with sufficient funding. Filing bankruptcy is like hitting the economic pause button in life. It's an opportunity to reorder one's financial affairs, but it isn't a method whereby an individual can indefinitely keep a house without paying the debt secured by the property. Plans with negative amortization and that have balloon payments may not be confirmable in Chapter 13, but under certain conditions they may be so in Chapter 11 if there's an option based on individual circumstances. While many debts may be discharged in a Chapter 13 case, provided that the case is successfully completed, secured creditors have rights in the real property, and unless the creditor is adequately provided for under federal law, Chapter 13 will generally only delay, not stop, a home foreclosure. Thus, to successfully save a home in Chapter 13, a debtor should propose a plan that provides a home mortgage creditor with adequate protection before the debtor's proposed Chapter 13 plan can be confirmed. The failure to provide for such adequate protection may result in the creditor filing a motion for relief from the automatic stay to allow the creditor to pursue non-bankruptcy remedies such as foreclosure, which is exactly what the Chapter 13 case was intended to prevent. Let's ask James Voidhover, a career bankruptcy law clerk, how the court generally evaluates a secured creditor's motion for relief from the automatic stay in a Chapter 13 case when such a motion is filed before the hearing on confirmation of the Chapter 13 plan.
In its simplest terms, adequate protection in a Chapter 13 case is provided to a mortgage creditor by first filing a proposed plan that proposes to cure any mortgage arrearage, as well as continue making the ongoing contractual payment. Additionally, adequate protection is provided by making the first payment under the plan, which would include the mortgage and cure amount, maintaining insurance on the property, and having a plan that is feasible to complete. We will now look at each of these aspects a little bit closer. First, the proposed Chapter 13 plan must propose to cure an arrearage if any exists. Additionally, the plan must maintain the contractual mortgage payment. And this is done in the Northern District of West Virginia in Part 3 of the model plan, as shown by this example. Next, in Chapter 13, the debtor's first plan payment is due 30 days after the filing of the Chapter 13 petition. In most cases, a wage withholding order will be entered by the court directing the debtor's employer to remit the plan payment to the Chapter 13 trustee. Whether the payment is made by wage withholding order or directly from the debtor, making that first payment and maintaining payments during the pendency of a motion for stay relief will help defend against the court granting such relief. If a hearing on a creditor's motion happens to occur before confirmation before the confirmation hearing, it may be sufficient to explain to the court that the wage withholding order is in place and that the first payment is scheduled to be made when the debtor receives his or her pay. Third, the proposed plan must be feasible, or at least the debtor must show preliminarily that there's a reasonable prospect that the plan is feasible and can be confirmed. Feasibility generally is reviewed by looking at the debtor's income and expenses and disposable income available to pay unsecured creditors, including the amount to cure the mortgage arrearage. Here, in this example Chapter 13 plan, the debtor proposed to pay $268.85 weekly in the Chapter 13 plan for 60 months, resulting in a gross base of $69,900. Under the plan analysis, the debtor is shown to interested parties, including the mortgage creditor and other unsecured creditors, that the amount of the plan base is at least sufficient to pay a return to unsecured creditors under Section 5.4 of the plan, including to cure the mortgage arrearage, which in this example is $52,564.80. Then a comparison is made to the debtor's Schedule I and J to see that the debtor has adequate disposable income to fund the plan. Provided that the debtor has sufficient income after reasonable and necessary living expenses, the plan is likely to be feasible. Finally, a debtor must insure a creditor against risk of loss of the property. If a debtor does not have insurance, the debtor should immediately take steps to obtain it, or the creditor may, in some instances, force place insurance. But in any event, the absence of insurance is a significant risk factor and will often lead to stay relief. When these 4 items are in place following the filing of a Chapter 13 plan, the debtor will be prepared to defend against a motion for stay relief while they await confirmation of the proposed Chapter 13 plan.
The next step concerns the filing of the secured creditor's proof of claim. Upon the filing of a Chapter 13 bankruptcy petition, a debtor must submit a mailing list containing all of the addresses of the debtor's creditors. Then the bankruptcy clerk's office issues a notice of Chapter 13 bankruptcy case. Among other important deadlines, the notice issued by the bankruptcy clerk contains a deadline for the filing of a proof of claim. The general rule is that a creditor must file a proof of claim with the bankruptcy clerk to be paid in a Chapter 13 bankruptcy case. From a debtor's perspective, when the debtor desires to save a home from foreclosure, the debtor wants the secured creditor to file a proof of claim, although the filing is optional by the secured creditor. If a creditor fails to timely file a proof of claim within the stated deadline, which is 90 days from the petition date, the debtor has an additional 30 days to file the claim on the creditor's behalf. When the secured claim is filed, it should be examined by both the Chapter 13 trustee and the debtor or debtors to ensure that the claim is not objectionable. Let's ask Michael Claggett, an attorney in Fairmont, West Virginia, what he looks for when he examines a proof of claim filed by a mortgage creditor.
When I've got a client who claims to be current on their mortgage payments, then what I want to do is I want to examine the proof of claim to determine really 2 things. Number one, whether the creditor would agree that they're current. And what you look at is really not the proof of claim itself, but the attachment. And Part 3 of the attachment says arrearage is the date of petition, and it should say 0. And then the payment, monthly mortgage payment, should be the same monthly mortgage payment as we already have. So that's the first thing I'm looking for. Oftentimes I'll find a proof of claim in there and they have them down as 1 payment behind. And that's more than likely because the payment's crossed in the mail. When I'm looking at a proof of claim that I already know is in arrears and the trustee is going to be making the payment, then what I'm looking for is everything all the way across on the attachment, and checking out especially the arrears at the date of the filing, and oftentimes then that changes the monthly mortgage payment, and I look at that first of all, and of course below that should be a loan payment history since the client was in arrears, so I can get an idea how accurate my client was on information. So we have to look at that, and then we're looking also at the new escrow analysis, where we see whether or not 2 things have happened. Number one, whether they sneaked some of the arrears for escrow back into the analysis which we've seen on more than one occasion, and if the pad seems ridiculous that they've invented out of thin air, and to see whether or not, in other words, the payment has some relationship to the previous payment, with some reflection on whether or not the previous payment took into effect the fact that their property taxes went up, the fact their insurance went up.
If you notice something might be amiss, what steps do you take?
Well, at this early stage, since there's not a notice of mortgage payment change, I generally just object to the whole proof of claim and then set forth my reasons.
And if a creditor holding a debt secured by the debtor's principal residence fails to timely file a proof of claim, do you file one on behalf of the creditor?
You pretty much have to get some kind of control, because the trustee is just not going to want to confirm the plan with no numbers. And that's sometimes we won't get one filed by a creditor who the debtor's current with the payments, and so that's pretty easy, because as long as we've got some kind of a statement, we can. And most all of the deeds of trust are available online anymore from most counties now, and so it's pretty easy to put one together. And of course, we always make sure on our copy of the Part 1 that it does indeed say that they're current with their payments.
And why is this advantageous, and how do you obtain the information necessary to complete the mortgage proof of claim form?
What we're looking for is how much is owed, what the monthly payment is, and then they're doing me just attach a copy of the deed of trust. And like I said, deeds of trust are almost all available for most counties now online, and so it's not that difficult to put one together. And then that, of course, then kind of locks them in also that they're current with their payments, because we're going to put that on there because we're going to definitely fill out the mortgage attachment. We always attach that. At least I do when we're filing our proof of claim for creditor.
If you notice that a secured creditor has forced placed insurance on the property, what steps do you take to have the forced placed insurance removed?
Well, generally speaking, most of my clients, if there's forced placed insurance on the property, it's because they haven't provided the insurance. That happens for two reasons. Number one, they were originally in the note. The client was supposed to provide the insurance, and then the insurance company was just simply to send the notice of the declarations page to the creditor every year. And then something happened, like a tree fell on their property, and even if it was the only tree, of course, their insurance doubled. And then at that point, the client can't afford the insurance, or something else happened. Very seldom do we actually have of the fact that they actually had insurance. We get that occasionally, and of course, we would get the declarations page from the agent, and we would contact the creditor. First of all, we'd send it to where it's supposed to go, and make sure that the agent has that information on there, and they generally cancel. They'll normally cancel that pretty easily.
If the debtor or the Chapter 13 trustee believes that the creditor's claim is objectionable for some reason, then the parties have the opportunity to appear before the court to resolve the objection. If the claim is not objected to, the amount of the arrearage and the amount of the ongoing payments listed in the proof of claim take priority over what the debtor listed in the proposed plan. In many cases, the filing of an amended plan is not necessary unless otherwise indicated by the Chapter 13 trustee's office. The requirements for confirming a Chapter 13 plan are beyond the scope of this video. With regard to securing an existing arrearage and maintaining payments on the long-term mortgage debt, however, the plan must propose to pay the arrearage in full, which may be done at 0% interest over the duration of the plan, and must propose to maintain payments on the long-term secured debt. In the Northern District of West Virginia, both payments on the arrearage and on the long-term debt must be made through the Chapter 13 trustee and not directly to the secured creditor by the debtor. When the mortgage is on the debtor's principal residence and the term of the mortgage is longer than the Chapter 13 plan, the long-term debt may not be modified and the debtor's obligation on the secured debt is not discharged in bankruptcy. After confirmation of the plan, then most of the administrative and legal work necessary to have a successful Chapter 13 plan is finished. For the most part, the debtor need only maintain ongoing payments to the Chapter 13 trustee and comply with periodic requests for tax returns and/or other financial information to allow the Chapter 13 trustee's office to monitor the plan's progress and ongoing financial condition of the debtor. When an individual saves a home from foreclosure in a Chapter 13 bankruptcy filing, Federal Rule of Bankruptcy Procedure 3002.1 contains several provisions that relate to changes in the monthly mortgage payment and how a lender must disclose the expenses and fees it charges and adds to the secured debt payments. In brief, 21 days before a change in payment is made, the secured creditor must file a notice of the change in the bankruptcy case. If the individual disagrees with the payment change, there's an opportunity for a hearing before the bankruptcy judge. For fees and expenses that are recoverable under the lender's loan documents, the lender must provide notice of the charges in the bankruptcy case within 180 days after the fee or expense was incurred. The homeowner then has 1 year in which to object to the disclosed charges. These two provisions require a secured creditor's participation in the bankruptcy case. In this way, after a debtor exits Chapter 13, the individual is not blindsided by accrued but undisclosed charges that were incurred while the debtor was under the protection of the Bankruptcy Code. After completing all payments under the Chapter 13 plan, the debtor begins to make the ongoing mortgage payments directly to the secured lender. In the bankruptcy case, the Chapter 13 trustee issues a notice of final cure detailing the amount paid by the trustee to the secured creditor. Under Federal Rule of Bankruptcy Procedure 3001.1G, the lender must assert whether it agrees with the trustee's notice of cure, and if not, state the amount still owed. At the time of this video, there is a proposed national rule change to have a mid-case review of the mortgage that mirrors the procedure for the notice of final cure. Whether the mid-case review comes to fruition or not, between the lender disclosures of fees and expenses, the notices of payment change, and the notice of final cure, a debtor should be able to exit Chapter 13 in good standing with the debtor's home mortgage lender. While the primary purpose of many Chapter 13 filings is to save a family home from foreclosure, Chapter 13 isn't the only bankruptcy method for curing arrearages and maintaining payments to a home mortgage lender. It is possible to accomplish a similar result in Chapter 7 of the Bankruptcy Code through the reaffirmation process, but a reaffirmation agreement is a voluntary action. The creditor does not have to agree. On the other hand, in Chapter 13, the debtor can use federal law to force creditor compliance. Briefly, in Chapter 7, a reaffirmation agreement is a voluntary act by the debtor. This is accomplished by indicating on the statement of intention that the debtor wishes to reaffirm the debt and then mailing a copy of the statement of intention to the lender. By agreement, the lender may or may not agree to work with the debtor in the reaffirmation agreement process to cure arrearages and/or modify the loan terms. Let's ask Todd Johnson, an attorney in Morgantown, West Virginia, about his experiences in using the reaffirmation agreement process to resolve mortgage problems.
There are a number of factors to look at. One is to see how far past due they are on the mortgage, find out the reason that they fell past due, see if there's a way that they can cure the arrearage pretty quickly without the help of a Chapter 13 repayment plan, see if they want to get rid of their home. If so, there's no reason to file a Chapter 13, but if there's ample reason to keep a home that's past due, that's set for foreclosure, then a Chapter 13 for sure is the way to go. I'd never advise a client to, in those circumstances, file a Chapter 7 and hope that they can cure the arrearage through a reaffirmation agreement. I'm pretty adverse to reaffirmation agreements. I think that they benefit the creditor a whole lot more than they do the debtor that I would represent in a bankruptcy. There is a potential for negative credit reporting if you reaffirm a debt and fall past due, and if you lose collateral that's on the collateral that secures a loan, there could be a deficiency balance if that collateral is sold at a foreclosure sale, or if it's for a vehicle, if it was repossessed and sold at auction. So certainly some negatives that can be avoided if you simply don't reaffirm a debt. As far as filing a Chapter 7 to see if you could enter into a reaffirmation agreement to cure a past due amount, I would never do that. I mean, that's one, loan modifications, in my experience, it seems like they rarely get approved. And I always want to go into a bankruptcy pretty much knowing what's going to happen, knowing what I expect to happen. And you just can't rely upon a lender approving any kind of loan modification to save a home in a Chapter 7. It's just not, people don't want to lose their home. Not worth going into a Chapter 7 with hopes that will work, because if otherwise a Chapter 13 will work, then the Chapter 13 rules can kind of get imposed upon the creditor, and then you know what's going to happen. That's a much better path to take. In Chapter 13, there's already a repayment plan that's established. So if a debtor falls past due on a mortgage during a Chapter 13, there's already a mechanism in place that can cure that. We'd have to tweak it and have the mortgage paid through the plan, but there's a way, at least in theory, that you can cure a past due mortgage through the Chapter 13. In a Chapter 7, again, if you're lucky, you can get a loan modified through a Chapter 7 through a reaffirmation agreement. But if you file a Chapter 7 then later fall past due, then there's really nothing there to protect you from the mortgage company foreclosing on the home. And if you reaffirm the debt, then that is a negative credit reporting situation, which is bad. You're still at risk of losing the home. And that you may end up filing another Chapter 13 after a Chapter 7 in order to protect the home. If you're past due on a mortgage, talk to a bankruptcy attorney. If you need bankruptcy protection to protect your home, you really normally have to file a Chapter 13. It's the only thing that makes sense.
Next, we asked bankruptcy attorneys in the tri-state area their experiences with clients who attempted to save a home through a non-bankruptcy mortgage rescue service.
I've not seen any successful, workouts with a mortgage rescue service. That's not to say that they don't exist, but I've not seen any.
Personally, my experience has been that you can't go past 100% failure, and so there's no such thing as 105% failure. So it's pretty much 100% failure. I mean, they do the same thing that the client could do themselves, except they charge the client money for them, which means that the client, having paid the money, doesn't have money to pay me. And number two, since the client paid the money, they assume that they're going to do all the legwork. And so the end result is pretty much 100% failure. And generally speaking, when the service tells them that they need to contact a bankruptcy attorney, it's about 2 days before foreclosure. So that's another problem with them.
Yeah, maybe anecdotal experiences here. I've heard stories about mortgage rescue services. My understanding is that they'll take your money and then try to help you get a loan modified. And with loan modification, there's really no guarantee that it's going to be approved in the first place. From what I've seen, that the approval rate of loan modification is low to begin with. And I think these mortgage rescue companies will basically suggest to you that they can get them approved at a higher rate, or maybe even guarantee that they can. And I don't think there's any chance of either of those things happening. I think they'll basically take your money, take your paperwork, and then provide that information to the mortgage company. That's best case scenario. And that's something that you can do on your own for free. And worst case scenario is that they just take your money.
Typically what we see with clients who have attempted a loan modification in lieu of filing a bankruptcy is it usually does not work. And what happens is they kind of are strung along for several months until they get weeks or sometimes even days before a sale of their home. And then they're suddenly calling our office for help because the whomever they're working with kind of comes clean and says, there's nothing more we can do. You're going to need to file bankruptcy to save your house. So it's a scramble to try and get them filed to save their home.
Pro se parties contemplating Chapter 13 often state to the clerk's office that if they had enough money to pay an attorney, they wouldn't need to file bankruptcy. In most cases, hiring a Chapter 13 attorney adds little to no additional financial burden to an individual because the vast majority of the attorney's fees are paid through the Chapter 13 plan. And when a debtor files a feasible plan that has a return to unsecured creditors, the amount of the attorney's fees being paid by the trustee is subtracted from the payment that would otherwise be made to unsecured creditors. In short, for those individuals watching this video contemplating Chapter 13, at least talk to an attorney that practices bankruptcy law before attempting to file a case by yourself and finding that you've been penny wise and pound foolish. Let's ask Kelly Coder, an attorney from Bridgeport, Ohio, how she structures her fees in Chapter 13, and how she advises clients who claim to have an inability to pay for an attorney.
There are additional attorney fees in a Chapter 13 as opposed to a Chapter 7. The attorney fees are higher because the representation lasts for a 3 to 5 year time period. However, in my office, the initial amount to file is comparable to a Chapter 7 bankruptcy, and the bulk of the attorney fees are rolled up in the Chapter 13 plan. So they are paid over that 3 to 5 year time period from the money that the client pays to the trustee. Personally, I do take typically about $700 up front of the fee, and then the remainder is rolled into the plan. But depending on situations and particular clients, sometimes I have taken less or even taken no money up front. I would definitely not recommend attempting a Chapter 13 without the help of counsel. There are several nuances to the filing. There are things that could cause your case to be thrown out. It is going to be well worth the money to have an attorney guiding you through the process. And additionally, in a Chapter 13, if you have to have some sort of money coming in order to make the payment. So there should be some sort of way to structure some payment for attorney fees in a 13. Typically, what I see when I've seen clients trying to file by themselves, they're either not filing things in a timely manner or they don't know the correct documents to file. And those are some of the most important things within the bankruptcy process. You need to be filing the correct documents. They have to have the correct information filed in a timely manner. You need to know when you start making your payments, where you make those payments to, making sure you appear at the hearings, and it helps to have an attorney guiding you through that.
This concludes our video presentation on Chapter 13 bankruptcy. If you intend to represent yourself in a Chapter 13 filing, all required forms and relevant guidance may be found at wvnb.uscourts.gov/filing-without-attorney. If you've recently found yourself in dire financial straits, we hope that this video has helped to make clear the Chapter 13 process and enabled you to take back control of the direction of your financial destiny.